welcome back, everybody. It's 1:40-ish, and we're going to have our last hour of pretty much just your questions and our answers. So there's a whole lot of them that are out there pending, both from the earlier sessions today and from just a few minutes ago. So basically, we're going to have Karen just run down them one after another. So if you have more questions, feel free to send them in, and hopefully we'll get to them.
Okay, so this one is for Josh, based on wage and hour, and they wanted to know if the person will be paid mileage.
So the question, I think, is if somebody is engaged in compensable driving time, do they also have to be paid mileage? Generally, no, although it depends where they're driving and that sort of stuff. So under the federal laws, mileage is not required. Under state of Maine wage and hour laws, mileage is not required. You certainly can if you want to, but you don't have to. There are certain states that have different requirements, like I know Massachusetts is one. So if you have employees down there, or if they're working for long periods of time down there, it might be different, but generally the answer is no.
Okay, and then this one is for Brent. What considerations, if our organization is interested in hiring a competitor provider who has a non-compete?
Well, I guess the consideration, it falls somewhere between yellow light and red light in terms of yellow light meaning caution at the very least. You'll want to have an attorney review the non-compete. The biggest concern is whether or not your organization would be taking advantage of any trade secret or confidential information from that employee, that if you hire that person. And I don't think turning a blind eye to it would work. And a trade secret could include things like certain techniques or know-how that is unique and learned by that former employee at the former organization, and that's not generally just general skill set sort of thing, because you could get sued directly under the Unfair Trade Practices Act if you yourself help to misappropriate or take advantage of someone else's trade secret. And so I'd be wary about if there was any, like I say, confidential information that might be a benefit to you. And especially it'd be risky if the reason why this employee is attractive to your organization is that you think he or she's going to bring something to you that he or she was privy to for the former employer. So that's sort of a short answer.
Can I chime in on that one? Another thing to at least think about is the possibility of what they call a tortious interference claim, tortious interference with a contractual relation. So there are some circumstances where if you hire somebody who's subject to a non-compete and you help them violate that, in theory, you might be contractual or tortiously responsible for that. How often does that actually come about in the court system? It's something that I see threatened often, followed through on rarely, and whether or not you would actually be in violation of that common law is another question entirely. But it's something to think through as part of your yellow light analysis. And I think if you're going to hire somebody who's subject to a non-compete, you should probably have a lawyer look through it and talk to you about it before you go ahead and do anything.
And a quick follow-up to that, because I did want to mention that and one other thing. On the tortious interference claim, I believe, at least under Maine law, current Maine law, they would probably have a weak tortious interference claim against your organization. But that doesn't mean they can't bring that claim
Right.
and embroil you in costly litigation. The other practical consideration is even if the other employer doesn't sue your organization, if they sue your employee or get a court order or something, you might not have a very dependable employee because they might not be able to work for you, as it turned out, or they may not be able to do what it is you thought they could do for you. So as I say, it's somewhere between yellow and red.
Okay, and then we have a question from Kathy, and I think John is going to take this one. What if an employee is paid a flat fee for a job? So for example, $100 for delivering a product, so that they are not paid by the hour and not salary either, but they're still an employee, they're not an independent contractor. How do we handle the earned paid leave for this group? Do we have to assign an hourly estimate to their job so that we can calculate the earned leave, or are they exempt from this new law?
Okay, so they're not exempt, and you're in a perilous position as it is, because if you're paying this person a flat fee, you don't know if they're meeting the minimum wage requirement. I mean, if you're traveling from Portland to Caribou for $100, then you probably are not. Most of the time, maybe it's fine, but you need to keep track of those hours so that you can ensure that you're paying the minimum wage. Now, beginning January 1st, you should be tracking hours as well, so that you can track the accrual of the earned paid leave, or you can still do the front loading, which will obviate the need for the keeping the track of the hours for that purposes, but you still have the minimum wage issue. So you really ought to be tracking hours either way.
But in calculating the actual amount that they would be paid for their earned leave, so the law says that you base it on the week prior to the request for the leave. And if this person only delivers once every 6 months, then I think you'd have to look back, well, assuming they actually, well, and how are you going to figure out how they earn, what hours they earn anyway, if it's a flat rate and you're not keeping track of how many hours they're delivering? Because the rate at which they earn this
Right.
leave is directly related to the actual hours they
Right.
work.
That's correct.
You have
And
to-
why is this person not an independent contractor? That's what I want to know.
That's
Yeah,
Right, because first you need to get the hours, then you need to figure out how much time they actually accrue. And then, assuming they do accrue any time, you're supposed to use the week before the leave, in which case,
for the rate of pay.
for the rate of pay, but this might have been 6 months ago when they delivered the last package. So you'd have to break down the amount paid by the number of hours they took to deliver it, and that would give you your base rate to determine
Yeah.
how much the earned leave would be paid,
But if they're
right?
doing it every week and it's different amounts, then you could be looking at a complicated situation. So
Yeah. I'd be
Okay.
interested to know why that arrangement.
Another question from Amanda. Can we do our payout of the time based on status? So for example, can we pay out for full and part-time and not the per diem?
No. You mean under the
But
earned leave
under
law?
EPL, I think you can
I
if you're
think-
treating similar employees similarly.
Wait, no, what? Oh, you mean
when they
payout?
leave.
No, okay, right,
employment.
gotcha.
Yeah, I think
On separation.
I think you can do that as long as you have a clear policy that says it and you treat like positions the same. I think you can do that.
I agree.
Okay, what if we have vacation and sick leave policy? If we don't require them to tell us which category, can we simply ask them which leave they want if it falls under this? Is it okay? Or is that a gray area?
I think what you can do is, assuming that the characteristics of your policies match everything that's required under the law, like we discussed earlier, you can say the first 40 hours of leave that you take in a year for whatever reason, we are making the decision that it's being designated as earned paid leave law. I think you can do that. I don't think you need to ask the employee, do you want it categorized in bucket A or bucket B?
But wouldn't you have to reduce their other buckets though by that amount of time? So you either have to know, or you have to, so let's say somebody had 40 hours of sick and 40 of vacation. And then they used 40 hours of EPL. You either have to say, tell me which one you want to pay down.
Okay.
Or you could reduce both and give them
Pro
only
rata.
half, only 20 hours each. And then they can use that however they want after the 40 of EPL.
You could do that. Or I guess you could say the first 40 hours, you have to take it out of bucket B.
Right.
and we're just gonna do that, and that way they know ahead of time.
And that's the trouble that I've been running into in trying to
Right.
formulate these policies, because you're gonna find that employees do not want it coming out of, well, either bucket really, because if you take it out of sick, then that's time that they're trying to use during the leave for the year for other stuff to save vacation. If you take it out of vacation, they're not gonna be happy because that's time they won't be paid out at the end of the year. One way around that, though, is to make EPL payable at the end of the year if they don't use it, because then there's no downside to them, no matter which bucket you take it out.
Now, if,
Right?
That's true.
If-
And if you're reducing the vacation accordingly, so you're still maintaining the overall number, it works out even.
now, if, let's say you get to the end of the year and you give people, you say, okay, you've used 5 hours, so you've got 35 hours of your earned paid leave left. We're gonna pay you for those 35 hours. What if the employee says, no, I don't want you to pay me for that. I want to keep it and I want to roll it over the next year.
Then they roll it over to the next year and they can earn 5 more. and
So
that's
you
it.
can't require them to accept the payout of it.
But there's no real incentive not to, because if you roll over 35 hours, that means you're only eligible to gain 5 more hours before you hit the cap for the year. So a rational employee would say, give me the money.
Or if they don't want to have to wait to accrue it, they might say, I know I've got a big trip or something that I'm doing
That's true.
right off the bat and I
That's
want to
true.
have 35 hours right available to me.
I think you can do either. I think you just have to have a policy that says, this is what we're gonna do.
As a school, do you need to have MEPL for the teachers?
Yes.
Unless
Unless they're in a current.
Unless you have a
collective
current
bargaining agreement.
CBA. If you're under a current CBA, this law doesn't apply until that CBA is renegotiated and expires. So you're good for now, but it will be implicated going forward under the next one.
Good point.
And that will be fun to negotiate. That
Yeah.
will be-
It will.
We do those.
So
Well
a
done.
question from Tracy, for a seasonal industry, is it the industry or how long the EER operates? Or are there examples of industries that meet the seasonal requirement?
I think it's both.
Yes. What- You want to answer? I have the
No,
regulations.
if you've got something authoritative, then it's
I
probably
do.
better than.
I always have authoritative. Yeah, actually, that's addressed specifically in the regulations that were issued and also the frequently asked questions and answers by the DOL. And it defines, it says right here, can you explain the exception for seasonal employees? And it says it expressly exempts seasonal employees as defined by the Employment Security Act. So in other words, if they're exempt under unemployment, then they're exempt under earned paid leave. But if they're covered under unemployment, then they're covered under earned paid leave. So I would recommend checking out the regulations and also those questions and answers.
Upon departure, can we pay out unused EPL to benefit eligible EEs and not pay it out to non-benefit eligible employees?
I think you can, as long as you're treating similarly situated employees the same. I'm not sure that it would be the wisest thing to do, just because it may not look good for your employees to see the difference. But I think as long as you're treating similarly situated employees the same, I think you can do it. Because you're not required to pay it out at all. And so.
Would it depend though on why somebody was non-benefit eligible? I mean, if it's based on, I don't work enough hours, that's one thing. But what if somebody was excluded because of a pre-existing condition? Then you're treating them differently because of a medical condition. Am I overthinking that?
I don't think that usually the reason you don't get a benefit is that you're part-time.
Okay.
Right.
It's not related to because you've got a medical condition. There are other troubles with that.
All right, well, if that's the case, then yeah, I agree with that too.
Okay, the year-to-year carryover, is it anniversary year or calendar year?
Anniversary year. It's the employee's anniversary.
Okay, if we currently have a vacation policy, can we change the wording to make it EPL? Or do we have to keep the vacation policy and add EPL to it?
personally have done it two different ways. I have, in some instances, I have created a separate EPL policy and subtracted that amount of time from the vacation policy and kept both. And other times I have integrated it into the vacation policy, and it's now vacation / earned paid leave. So it depends on what you want to do and how your existing policy is set up. It may be more amenable to one way or the other. How's that for non-answer?
Okay. We allow employees to carry over 80 hours of unused vacation time to the next year. So if an employee uses 40 hours of EPL, they can roll over their 40 hours vacation time and then accrue another 40 hours of EPL in the next year and accrue another 80 hours of vacation time.
It depends on how you word your vacation policy. So they certainly get to carry over their 40 hours of EPL. Whether or not you allow them to accrue vacation time of 80 hours, 40 hours, or 0 hours in the next year is up to you, depending on how you want to structure that.
Yeah, that's one of the changes that you might make in amending your personnel policy, is no longer allowing 80 hours of vacation to be rolled over, knowing you've got 40 hours of EPL that can be rolled over. Maybe you say it's 40 and 40 instead, but you could allow them both.
Okay. Is it a mandate that ERs offer PTL to include vacation and sick? Or is it okay to have vacation 80 plus 40 of sick time? Sick time is not carried over in this person's organization.
I'm not sure I understand what they're asking.
Repeat the
So
question.
it's
Can
a
you
medical,
separate out sick and vacation is the way I read that.
yeah,
The
so it's a
answer's-
medical professional.
If the question is, do you have to have a PTO policy that includes all leave non-designated, the answer is no. You can have whatever you want. You can have PTO or you can have sick and vacation.
Okay,
If the question is something different, you guys read that
I
differently?
can't, which question is it?
The one that's
The one
at
at the
the
very
top.
top. Their mandate. I'm not sure if this is what it's asking, but I'll take a stab at it. And if I butcher your question, let us know. But I think what this person is asking is, if we have a vacation policy and a sick time policy, can we keep those policies and just incorporate paid leave into those? Or do we have to make a separate policy? And I think that you can do it however you want. You can have a standalone earned paid leave policy, or you can incorporate it into an existing vacation or sick time policy. You just need to make sure that you're hitting all the bare minimum requirements of the new law.
Yes,
If that doesn't answer your question, I apologize, and let us know.
I agree with that. I think that it appears that's what it's asking. And as long as each type of leave has the correct characteristics, you may have to expand the reason why. Well, no, I think as long as it has the correct characteristics for the first 40 hours or 20 hours, that would
Right.
work. So it's really a question of how you integrate that into an existing policy. And sometimes, frankly, it's not worth it to even try, because it makes your policy so complicated that it's just going to be easier to have a separate EPL instead of trying to create this complicated matrix.
and then
And
if,
I hate to interrupt, but I don't want to just leave and have you wonder. I need to leave. Thank you all so much for attending this year's employment seminar. I hope I see you all next year again. And thank you all. And I'll see
Thank you, Brent.
thanks, Brent.
Aye.
So another question from Elizabeth, if EEs are exempt and extra hours are needed for a project, they do not get paid extra. They might do this work at home, correct?
Well, if they're exempt,
Yeah,
they're not being paid by the hour.
yeah. So if they're truly an exempt employee, they get their salary regardless of whether they work 10 hours in a week or 100 hours in a week. And if they have to put in, even if their average is 40, if they have to put in extra hours to complete that project, that's subsumed within their salary. You can offer additional compensation if you want to as an incentive, but you're not required to.
Okay, in regards to the new earned paid leave law, if you are an employee that works 30 hours per week, they will earn 1 hour for every 40 hours worked. Is the total number of hours they can accumulate 40 hours or only 30 hours?
40.
It's 40 hours.
It's just gonna take them longer.
And at some point, if they're not working enough hours, there may not be enough hours they work in a year to get to 40.
Right.
So then in that case, it will be less. But right now, if you're working 40 hours, it's going to take you about 10 months to get your 40 hours. So if somewhere between 20 and 40 hours, you'll run out of time and start earning less.
Can an employer deny an employee's request for vacation time if they know the employee will be traveling to a non-exempt state?
I think no, I think you have to give it to them and then require that they quarantine or whatever when they come back.
I think it depends on if this is vacation time or PL. If it's EPL, that might be a different
Right.
language answer. But for just plain old vacation time, I think you can.
I think if it's regular vacation time, you can tell them, we're not gonna let you take the time for that purpose. I think that's within your
You're
rights.
just mean.
It may not go over all that well, but I don't see anything that prohibits you from doing that.
But come next year, EPL would be different because that
Right.
would have to, well, I guess you could perhaps show as an undue hardship, but that would be a
Right.
different step you have to take.
Okay, with regards to employees that are tested for COVID, are we able to tell employees that they have to get one type of test versus another, so a rapid test versus a swab, before they can return to work?
I don't think so.
Yeah, I'd be reluctant to say,
I wouldn't
get
get
this
into-
kind
Yeah.
of medical
Yeah.
procedure as opposed to
Yeah,
another.
I wouldn't
Yeah.
get into medical issues at all. Because it may be what's available and maybe they can't do one kind or another. I wouldn't touch that.
So an employee is a cleaner in a healthcare clinic, and there are not 50 employees within a 75-mile radius. They have a doctor's note that they should not work due to a household member's health condition while exposure is possible. They do not qualify for FMLA. Can we discharge them from employment?
Well, this is similar to a lot of the ones that we've addressed now. My first question would be though, I take issue with the last sentence because they may qualify for state FMLA. So I don't think you're out from the FMLA analysis at all. However, if the household member, it depends on whether or not the household member has a serious health condition. It sounds like they might if they have something that could be that much aggravated by exposure. But if they don't have a serious health condition, then it wouldn't be covered under FMLA anyway, or that you're not needed to care for them.
Right.
That sounds like a call Anne Marie question.
Well, that comes back to FFCRA and what I read about the caregiver leave law. And in fact, that's probably directly applicable to that situation. Don't fire them until you talk to somebody.
Okay, so from Kathy, for the EPL law, can we write a company policy that states that upon termination, we will pay EPL to all benefit eligible employees, but that we don't pay it out to non-benefit eligible employees?
Didn't we answer because
Yeah.
Yeah,
Can we answer that one?
we said as long as you keep everyone in the same category being treated consistently, yes. You just got to keep in mind that if one of those people who didn't get the payout comes back in a year, then they get it restored.
I was just trying to, confuse you guys by asking the same question again. Okay, another one, clarification for my question regarding health benefits. I was referring to caregiver leave law. This employee is an essential health worker and not covered under FFCRA.
I mean, I don't know if you guys know off the top of your head, I would have to go back and look up the specific provisions of the caregiver health, because all I have is the section that talks about why somebody's eligible. I don't have the rest of it.
Yeah.
Okay, can you ask an employee that needs to be out of work based on either having COVID or having direct contact with someone with COVID for a copy of the COVID positive test as proof?
Well, I certainly wouldn't be asking for a test result from a non-employee. Because it sounds like if your employee was in direct contact with somebody, so that's presumably some third party who's not an employee, I probably wouldn't be asking for that person's medical records. The test result for the employee, I think, is a closer question.
I think I would probably ask for a doctor's note confirming as opposed to the
Yeah.
actual test result, because
think-
I don't know what else is on there and what info you might
I think
get.
that's the better course.
Okay. If you are paying staff who are sent home due to a snow day, do you need to pay the remote person staff as well?
I say no.
I say no as well.
All right.
Yeah.
We asked the DOL the same thing. They were classified as IDs, and then DOL had us reclassify them as employees.
This
Oh,
was
that's
the
right,
package
yes.
carrier.
Interesting.
Okay.
Well,
Right.
I mean, I guess it goes back to what we said, which is you gotta calculate the hours that it took them to do the delivery and come up with a base rate of pay that's gotta be over minimum wage. And then when they go out, you apply the last time they worked, right?
Yeah.
Whatever that base was. Right?
I agree.
Okay.
I think you gotta be careful when you start telling these people to start tracking their time. Don't put any bugs in their head that there might have been a problem in the past.
Going back to the snow day question, it's not that you're not paying the remote worker should be still working, that's all.
Oh, good point.
Yeah.
Good clarification. No more snow days.
Nope.
But there could be internet interruptions.
We have a current PTO policy which states we will pay out the unused accrued balance should they terminate. Employees may also carry over hours. If we create a separate EPL policy, can we handle it differently and not pay out PTO if they have leave and not provide the carryover option?
The carryover option is required for EPL, but you can have a policy that says that EPL is not being paid out.
Correct.
So you might want to merge the two so that you don't end up carrying over twice.
Can
It's
you,
only 5 days.
can you clarify if it's mandatory to have cloth masks, or can employees wear a shield if they prefer with the new order?
I would suggest you check the CDC because at one point, and I don't know if they still are, but they were saying that the shields are not effective and you need to have a mask and a shield. So I would go straight to the CDC and see what they say about what works and what doesn't.
And the governor's order recently actually says cloth masks.
Right, that's right, in one section of it.
Do these rules also apply for nonprofit organizations? The exempt EE at a minimum of 701 per week.
What was the last part?
Yeah, so the exemption amount, in terms of the salary basis test is the same, regardless of whether it's a for-profit or nonprofit employer, at least to the best of my knowledge.
What rules is she talking about?
I believe she's talking about the exemption for FLSA.
Oh, okay.
At least that's the way I'm interpreting the question.
Does EPL have to be paid out, or is it a use it or lose it unless you are rehired within that year and reinstated?
It's both, because you can roll over up to 40 hours. And if you do roll over the 40 hours, you do not accrue any more that year. So it's both, you roll it over, but it's also use it or lose it.
Okay. So from Megan, can you say more about non-competes in the context of business to business contracting? To be conservative, I've omitted non-compete, non-solicitation language in vendor contracts, but I'm wondering if you found any creative solutions to allow these provisions to stand, at least in the context of businesses contracting with other businesses.
So this is an area you have to be careful. There's a couple different considerations here. When you're talking employee to employer, it's one thing. When you're talking employer to employer or business to business, it's a different situation. So there's a couple things to keep in mind. Number one, along with the new non-compete law passed last September, they also passed a secondary law, 599B of Title 26, which prohibits restrictive employment agreements. And that makes it per se unlawful for two businesses to contract with one another not to hire or solicit each other's employees. Even having one of those agreements by itself, even if you don't do anything with it, is a violation of the law and is subject to a $5,000 penalty. So there's that to be, it depends on what you're talking about in terms of a non-compete from business to business, but that's one thing you need to be careful about. Another thing that you need to be careful about is whether or not you're getting into any anti-trade laws or antitrust laws, excuse me, depending on the nature of your business to business contract about not competing with one another. That could be an antitrust issue. So I'm not sure if that's what you're asking about, but you do need to be careful about restrictive agreements between two different businesses.
Okay. We currently have vacation, sick, and personal time, and maybe lumping the time together for staff. Will this cover EPL, or do we need to give staff more time?
Chances are it will be enough time, but it depends how much time you're giving them right now. 40 hours per year is what they're required under EPL. So as long as you're giving them that much at the correct or better accrual rate under the same terms and conditions as required by law, then you can do it. So you can, without more detail, I guess I really can't say whether that's true or false, but you need to make sure that there's 40 hours per year accrued correctly with the correct characteristics in terms of notice and so forth.
Okay, thank you. Elizabeth is coming back to, it's a nonprofit with all exempt EEs, so they have to be at the minimum of 701 per week. If so, then we would be impacted to have to increase pay to that amount. Have nonprofits been sharing any concerns?
I haven't heard any concerns about that, and I haven't looked particularly to see if there's any sort of exception for nonprofits. I'm not aware of one offhand. So I don't know what else to say about that other than, number one, I'd be interested to know if all of these employees do in fact pass all the exemption tests. But if they do, minus the salary issue, it's still not an issue so long as they're not working more than 40 hours in a week. So if you have somebody and you pay them $700 a week, and they would otherwise be exempt, but for the fact they don't meet the salary basis test, there's no penalty or negative blowback from that, so long as they're working 40 hours or less in a 1 week period. If they work more than that 40 hours, then you're going to have to potentially start paying them overtime. But if they're working within that time frame, then it's a moot point anyway. So
Okay, thank you.
I don't understand. Are they asking whether or not all of their employees are going to have to be elevated to this 701 per week and sort of insinuating that that's a hardship?
that's the way that I take it in order to maintain exempt status.
Yeah, because my response to that would be, why do they all need to be exempt? Maybe they don't.
Right.
I mean, if they're not working a lot of overtime in the regular course of their job, they don't have to be exempt just because they meet the standards, right? You can
It's your choice as the
unclassify them, and
employer.
then you just have to pay overtime.
It also seems unlikely that all employees would be qualified for being exempt under the other standards for the professional, executive, and so forth. But that's an aside.
Yeah.
Is there a way around allowing EPL to roll over? We revised our policy, so all paid time is in a PTO bucket. It means the other minimum requirements. However, it is a use it or lose it policy. It resets January 1st and employees start accruing again.
I think there is, and it's called pay it out at the end of the year. Otherwise, it has to roll over if there's some left.
I think the only other option would be to just give them on day one of the next year, front load them and give them all 40 hours, because then at that point, even though they haven't technically rolled anything over, it's a moot point because
That's
they've
the
got
same
all
thing,
40
though.
hours there.
So
So
you've just rolled it over.
you've effectively rolled it over, even if you take it off the books. So
And is this effective 1/1/21?
Yes.
No,
yes,
But we don't know what she means by, this is the same person that was just asking about the exempt. Maybe you want to call and, because I'm worried that we're not answering the question that you are asking.
EPL is effective 1/1/21.
Yeah, but we thought she was asking about minimum wage,
Right. Minimum wage
which is also 1/1/21.
right.
correct.
So I guess the answer is yes, no matter what it is.
And And it shouldn't be that big of a change from December 30th of this year to 1/1/21, because we're only talking about a difference of 15 cents an hour. So the weekly difference is, it's less than $15 if I did it. So, it's not a huge change in the exemption amount when we hit the new year.
Okay, and then somebody has asked if you could repeat the answer about carrying over or paying out EPL. They were having a hard time hearing, and I think this may even relate to the current PTO policy, which states we will pay out unused accrued balance should they terminate. Employees may also carry over hours. If we create a separate EPL policy, can we handle it differently and not pay out PTO if they leave and not provide the carry out option?
One thing that I want to mention about EPL carryover, that if you're talking about a calendar year, that's a problem because EPL is based on your anniversary year. So on 1/1/22, after that, or the December 31st of next year, after a full year has gone by, for existing employees, that's fine. But for new employees, you're going to have a different year. So when it comes to the end of the year, they may not have accrued all of their time for the year that year because they're not on a calendar year. Does that make sense? If not, then ask another question. As for the rest of the question, if you want to not have EPL carry over from year to year, then you pay it out at the end of the year, being the anniversary date or the anniversary date eve, so that then there's nothing to carry over.
And then Elizabeth asked or said, yes, I understand that it's not a big amount, but for one person who is paid $35,000 a year, it's an increase of $1,400 a year. This person is the communications coordinator.
Well, the current exemption amount is $36,000 for 2020. And so I just did the quick math for 2021. It increases to $36,450. So it's a $450 increase over the course of the year. So,
But then this person is not exempt right now.
the person who's making $35,000 right now is not exempt because they're underneath, they don't satisfy the salary basis.
So if you have operated under the assumption that that person was exempt,
Call Josh.
call Josh today.
Okay, and then Megan had a clarification. I'm not talking about business agreeing not to compete with each other. I'm talking about business that agree that they will not solicit the employees of other businesses for employment during the pendency of the relationship. I've taken all this language out of our agreements, but have you found any creative ways to allow these kinds of provisions to remain?
So that's a very interesting question. Generally speaking, 26 MRS 599B specifically prohibits that. So two companies cannot engage in agreement that they won't hire or solicit each other's employees. And that is a de facto violation of the law. There is one issue working its way through the court system right now, which is in the context of temp agencies. Because a lot of temp agencies have provisions within their contracts that say, if we place a worker with you and you hire them directly, then you will owe us a finder's fee of X number of dollars, which is a little bit different. The DOL has taken the position informally so far that they are not going to enforce 599B in that situation, but that is an issue that's actually pending in the Superior Court, and I think is going to get some legs, and it'll be interesting to see where that goes. But that's the only carve-out that I'm aware of, the potential carve-out, I should say, is in the kind of temp agency or placement finder's fee sort of situation.
Okay, thank you. Elizabeth said she's just going to call. And an anonymous person asked, if the employee leaves, do they have to pay out the EPL?
No. If you've got a policy that says you don't pay EPL out, then you don't have to.
Okay.
If you don't have a policy at all, then it's treated the same way vacation's treated.
Okay, at the NDOL webinar yesterday, they said that you could use your anniversary date or calendar year for the accrual?
I
haven't seen that.
was gonna say, I felt awfully self-conscious this entire webinar because I had also thought that that was an option. I'll have to go back and double check. I thought that to be the case as well, but I don't know for sure, so
Well, yeah, I
figure
mean,
that out.
and that would be good in some ways. It would just make it a little bit difficult for that first year until you get synchronized, but I hadn't seen anything to that effect.
Okay, and then Anne-Marie, one person was talking a little bit about workers' comp and just wants to make sure that you have spoken everything that you kind of wanted to talk about with workers' comp claims while working from home.
Oh goodness, I could talk about this forever. I mean, I guess we didn't get back to that. So there are a whole boatload of issues about working from home. And a lot of this gets back to why we suggested that there is a clear set of parameters in place for what the employee is actually doing at home, what their hours are, and more specifically, what their work setup is like. Because the kinds of claims that we see from people working at home, I wasn't being flippant when I said before somebody goes to get coffee and trips over the dog, because there are actually more of those cases than you might even imagine. And so then the issue becomes, did it arise out of and in the course of employment? Now that's different than in a work setting, because presumably there are no dogs to trip over in a work setting. But you wouldn't ordinarily limit somebody from going to get coffee. So that's the argument. You know, it didn't have anything to do with my being at home. I was taking a break just like I would do in the office. The other place we see these come up a lot is when somebody is coming or going into their house. And a lot of times it happens in the wintertime, and they slip on their stairs, or they slip in the driveway, or getting in and out of their vehicle. And then it's going to depend largely on what kind of employee are they. So are they a traveling employee, or do they still have a set workplace? Are they coming in periodically? Because, and where were they going at the time? So the claims that we see are like, for instance, I was going to get the mail and I slid in the ice and fell and hurt myself. And the reason I was getting the mail is because I knew it was work-related mail that was coming to me. So there's the connection. Or I was going out to get in my car to come to the place of employment to attend a required meeting. So these claims come up all over the place. And I can't give you a definitive answer about whether any one claim is going to be related or not related, because the decisions are all over the place. And it will depend entirely on an assessment of that person's individual situation. Having said that, there are ways for you to limit potential exposure, though, or at least recognize that you have that potential exposure. So defining the workspace is going to be important, so that an employee can't say, well, I had my earbuds on and I was allowed to roam around the house while I talked on the phone, and then I tripped over the dog, but that's okay because you didn't tell me I couldn't do that. So, you know, you have a set office, you're expected to be at your computer at your desk, you're not expected to roam around just like in a regular workplace. You may also want to consider having an ergonomic assessment of that workspace. As most of you probably are well aware, what your workspace at home looks like is often quite different and maybe temporary. Maybe you've got a computer on, you know, a pile of laundry. Maybe you're in your kid's room temporarily because there's no office space. So you want to make sure you have an actual work site that's conducive to working and isn't going to create a carpal tunnel claim, for instance, or a back injury. And then I would define things like mail. I mean, now it seems like you probably don't even need to send anything by the actual mail. Everything could be done over the computer. So going to the mailbox is not going to be necessary. But there are a lot of steps that you can take to try and limit your liability, but it's absolutely a risk, and in a lot of ways a bigger risk than when you have people in the office and have more control over what they're doing.
Okay, thank you. We have just a couple more questions. So for EEs hired before 12/31/2020, accrual of EPL starts with 1/1/21, and the calendar year is also the 1 year time period where the EPL accrual is capped at 40 hours.
Correct.
how is the 1-year time period calculated for new employees that are hired after January 1st, 21? Calendar year as well, or start of employment to 1-year anniversary of employment?
I would say from start of employment to 1-year anniversary of employment. Because that's the 12-year, that's a 12-year period. It's the same as if you were looking at them for a potential raise, for annual raise or something like that. But if DOL is saying something different, then there's going to have to be a mechanism to synchronize them to the current calendar or to the next calendar year. But I think that it is the anniversary year.
Okay, so unless somebody else has any other questions, I've got one final one. To be clear, there is no way around allowing EPL to roll over. We had combined all paid leave into PTO. However, is it use it or lose it? You should start over accruing on January 1st.
You're entitled to 40 hours of EPL per year. And if you don't use your EPL in that year, it rolls over. And if it rolls over, the amount that rolls over is subtracted from the amount that you can earn that following year. So the rollover is something that's stated in law, says that the employees may roll over up to 40 hours. So that's required by law. The way to avoid that is you pay it out at the end of the year, and then there's nothing left to roll over.
And this is anniversary year, not calendar.
I don't think we've,
At least for people, at least for the immediate future, calendar year and anniversary year, calendar year is going to be the year, because for existing employees, it kicks in on January 1st.
Okay. Thank you. That's all the questions that I have.
all right, folks, we really want to thank you for participating and for all your great questions and for allowing us to do this by Zoom this year. I actually think it turned out quite well, being able to have this discussion, and hopefully you learned a lot from hearing it. We certainly will take follow-up questions. It would be probably easiest if you directed them toward a particular person, any of us here at the table, and we'll do what we can to try and help you. And again, we appreciate your attendance and hope you have a good weekend.
Good night.
Thank you.
Bye.
Bye.